sure if any marriage, first is if due to impotency of either of the spouse, the marriage cannot be consummated. Because of the impotency of either of the spouse, it might be possible that because of the impotency, if for an year or so the marriage need not be consummated, the other party can ask for an element of marriage. It's not the party who is important who can ask for, it's the other party who asks for. The second is again, the second clause is your only clause 2. If clause 2 is not fulfilled, then it can be a voidable marriage. The third is that if the consent has been obtained by fraud, force or misrepresentation of a fact or concealment of a material fact. Fraud, force is easily understood. Someone putting a gun on your head, okay fine, take the pheras. It can be taken as a voidable marriage. Or fraud, taking someone, okay fine, you're going to be married to B, making married to A. Again it's a cheating and fraud. Again the marriage is void. Otherwise, when you talk about concealment of material facts, what do you mean by concealment of material facts here? In fact, you are told, okay fine, you're going to marry a boy of 25-year-old. After marriage, the girl came to know the boy is 55-year-old. Not a boy, man actually. Here is a concealment of a material fact. Or, about the status of person, that a person is already a widowed or has a child of his own from an earlier wife or somewhere, all these are material facts, which if comes to the knowledge, if you are not disclose it specifically about your marital status, about the issues you have, or with regard to your job profile also. You told, like in our India, अगर हम उसकी बात नहीं करते, हमारे marriages के ad आते हैं, उसमें सारे concealment of fact होता ही होता है. But in sense like that, okay fine, told it, okay fine, my son is earning such a high income and he's posted at a high post and all this, came to know he's a peon. It's a concealment of a material fact here. So it's not about, okay fine, we are discriminating with rich or poor. It's a concealment of a material fact with regard to a person's status, income. A question was regarding caste also. That if a person conceals his or her caste, then whether it can be regarded as a concealment of material fact or not, though we can say it will be against your section 17, but a different thing. It's my own wish on whom I want to get married to. I should not be forced to, whether it's it's not about the untouchability or with regard to or anything else. It's just about my personal fact. I want to be married in my own community. So how can somebody dupe me? It's a fraud. It's concealment of a material fact. So that concealment also can result in making a marriage annulled. When I talk about annulment of marriage, annulment can be two ways, either void or voidable. Basically, annulment we talk about in void marriages. When you say we have annulled the marriage, basically we talk about voidable marriages because void marriages for ab initio are annulled. There is nothing you don't have to annul them actually. With voidable marriages, you have to annul them in front of the court. Go to the court, tell them, okay, these are the reasons. No, I have been married by force, fraud, and things. The last is if the woman at the time of marriage was pregnant with a child of some other person. If the girl at the time of marriage was pregnant with the child of some other person and this pregnancy was not known to the man. If you already know that this girl I am marrying is pregnant, and then marriage is not the question. Or if the child is his own, the question is from other person and it should be not be known to the party. Then again, this has to be, the petition for this has to be filed within 1 year. Because obviously you came to know about this in 1 year only. It's obvious fact. After that, after 3-4 you said, okay fine, when I married, this child does not belong to me now. No, you cannot do that. Then you have to go for divorce, file for adultery or any other reasons for that cruelty, because I have to raise someone else's child or something. You can have divorce, but you cannot have an annulment in this regard. Again, after coming to know about the fact that your wife is pregnant with some other man's child, you have a sexual intercourse with her. Then also you forfeit your right to annul the marriage. After you came to know that this woman whom I got married to had a child of someone else, she's carrying a child of someone else, and still you have a sexual intercourse with her, then you forfeit your right for annulment also at that point of time. You cannot say, no, she was still my wife, so what's wrong with that? It's wrong, then you have to accept the child as your own. Because now it cannot be sure whether it's child or not. A person can do this also, no? We are not sure whether now you have to again file for divorce and prove it. There is no annulment available to you. These are for you with regard to your marriage. Ceremony, what are the essential conditions for marriage? Ceremonies for marriage, if all the conditions are fulfilled, like a section 5 and 7, it's a valid marriage. If few conditions are not fulfilled, it's void. Few not fulfilled, voidable. This in entirety is your marriage laws. Precise and simple. Understood? Clear? Let's jump to divorce now. शादी करा दी, अब divorce करना बहुत जरूरी है हमारे लिए. It becomes important. Obviously, if people get married, then obviously they get divorced. That is why we teach marriage first, because first you have to prove there was a marriage, then you can ask for divorce. Now the present trend is a lot of times people say, we were never married, what is the need for divorce? That's again a question now. We were never married, no need for divorce, let's just prove it. That's what the, say plus side of living relationship. There was never a marriage, no need for divorce, just walk out. That is why sometimes referred to as walk-in and walk-out relationship. That's not the reason for walk-in, and you don't have any kind of responsibility as such. For with regard to divorce, now they have given legitimacy to the children and everything else. Again, important thing. Normally, a child of, if you get, child outside marriage are illegitimate, right? But children of void and voidable marriages are legitimate children. Okay, children of void and voidable marriages are legitimate children. They are entitled to the property of their parents, not their grandparents. They are entitled to the property of their parents, not grandparents. And we talk about how they are entitled, because earlier also, if the child is illegitimate, he is entitled to only property of his mother, because he is nullius criminus. Only the son or daughter of his mother, not of the father. But if it's a child after a void marriage, okay, two people got married, they didn't know they were there prohibited degrees, their parents got separated, Kumbh Mela, they met somewhere in college, got married, later on came to know, my God, their first cousins. Now they get separated. And this is not hypothetical, there are cases with regard to that. And you have been taught those cases actually. There are cases with regard to that where two people got married and later on came to know that they are first cousins. So now obviously their marriage void, they have a daughter or son with that, though that child is a legitimate child. Because there's no fault of that child in it. And we in our Indian society have really, we play a very pivotal role in legitimacy as such. Illegitimate or bastards are not treated with respect. So that is why it's become very important for us as a society to help those people who have no fault in this. Even if a person is illegitimate, that's not his or her fault. It's the fault of the parents. Nevertheless, that is why for the current judgment of Supreme Court, even illegitimate children have been given rights in the property. Illegitimate have been, though this can be said as to be judicial overreach, because it's not allowed by our law. But again, we say that okay, needs of society are there. Okay, by DNA testing, which proves the child is theirs. The famous case of the recent case of yes, N.D. Tiwari, right? Thank you. The case of N.D. Tiwari, the son has been given right in the property. Though according strict understanding of whoever understands the legal principles, it is not allowed. And should not be allowed, because he's not given the property of N.D. Tiwari, but also his great, the joint family property, ancestral property. But again, they say that it's because of this societal pressure or whatever, for society only. Again, we don't, again a Supreme Court judgment can be criticized, but we cannot say that no, we cannot follow it. Not unfollow it, we can criticize it at the most. The divorce also, there are two concepts. Divorce has a lot of theories. The first theory we call it as fault theory, and the fault theory means you find fault with the one party or the other. Matrimonial, committed a matrimonial offence. What kind of matrimonial offence? You commit adultery, you commit desertion, you commit cruelty, you leave the person for 7 years, that's kind of also an offence. Or there is some other matrimonial conditions. Conditions like he's suffering from venerable disease, suffering from leprosy, incurable leprosy. He has converted to some other religion, that's also an offence actually. If you convert to some other religion, that might be your fault if you want to convert, but was the fault of that party. That is again an interesting area, where if you convert, the party who has converted has no right to divorce, but the party who has not converted has to contest for divorce. Here, if the party who has been wronged, only that party has the right to contest for divorce, not the other party. Either both, when they contest for cruelty, they say, okay, my husband is cruel, my wife is cruel. That is the most probable examples we give. That is your fault theory. Next is your mutual consent. They both agree, we don't want to fight, we know what exactly our Indian scenario is, we don't want to wash our dirty linen in public, let's agree for a mutual consent divorce. It's simple and easy, and there have been 2 to 3 years. If both the party agree throughout the divorce. The third is, which is not found in your statute books, that is your irretrievable breakdown of marriage. Irretrievable, something which cannot be retrieved.
Breakdown of marriage.
Irretrievable breakdown of marriage. Something which cannot be retrieved, something which has been broken. Example, a glass, if you broke it, you cannot retrieve it. You can never retrieve it, you cannot put it in the original condition. That is what they call that irretrievable breakdown of marriage. But the problem is, this particular is not available with your statute books. It's not there anywhere, as such not there. In totality, it's there in a part with regard to 13(1)(a) to an extent. But as a rule, if you say that my marriage because of, no, what do you mean by irretrievable breakdown of marriage? We belong to different state of minds, attitude problems. You know, there is no fault with this person, but I cannot adjust this person. He's a very nice man, he's a very nice woman, but I cannot adjust. I cannot see my future with this. You know, something which, you know, we cannot retrieve it because we don't feel anything for each other. In India, this is no ground. Sorry, you have to adjust. You have to adjust because society is based on the theory of adjustment. You have to adjust every scenario, whatever you have to adjust. So in India, you cannot say, okay, fine, though we two are very nice people, we have everything, don't let us, you know, throw all these of, you know, first petition, then second petition, and all those, and you can easily go on, we don't both agree with the point. But they said, no, we don't agree. Try. First, again, work for a marriage for a year or so. Remember this, no divorce can be obtained in first year of marriage, section 14. You cannot file for divorce in the first year of marriage because according to them, first year is a crucial period. Try to adjust for 1 year. For 1 year, live in hell first, then we'll talk about whether we'll grant you heaven or not. That can be taken as one philosophy or other also, that when you start living with one person, it is difficult for initial time. So we're giving you time for adjustment. So in the first year of marriage, except in exceptional circumstances and, you know, unbearable hardship, a divorce petition can be filed. We have a case where two sisters were married into the same home, and these two sisters on the second day of marriage were put in a, you know, kind of a room without light, without fan, anything else, and not given food for 7 days continuously. No food, no water, no outside control. So obviously, this is extreme circumstances. Here the court cannot say, no, go for 1 year, stay there for 1 year, when you die, we'll give you a divorce. Obviously, they are always an exception. Our whole law is based on exceptions. There are few general, but exception. But this has to be an extreme condition. Not, okay, first day of marriage, I cannot, you know, adjust with this person because he comes so late in the night, I want to sleep early in the morning. I know, I am a morning person, he's a night person. For 1 year, try to adjust. You became a little night person, he became a little early morning person. So adjust for 1 year. You have to prove that there are unbearable circumstances where you need to get a divorce. When you talk about this, mutual consent is provided under your section 13B. Whereas your fault theory is provided under section 13 clause 1. That is your there, and again there are few more clauses. 13(1) talk about 7 grounds. That means in your Hindu law, you have to prove the incapacity of the other person. They are ground basically. Because with mutual consent, there are a lot of difficulty. In mutual consent, why we have less mutual consent divorce in India? Because with mutual consent divorce, you will always sign a kind of a agreement. In an agreement, a woman can lose a lot of rights. Okay, fine. If she wants mutual consent divorce, she can say, okay, fine, I won't pay the maintenance. But then again, Supreme Court has come with new things that maintenance is a right. It's not given by you and you take away. Maintenance is a legal right given to. So a person cannot by contract take it. If it's a legal right, it can be only taken by the parliament. So even though if in a contract a woman so wants to free from marriage that she agrees for a mutual consent divorce on the ground that she won't contest for a maintenance. Later on still she can contest for maintenance. Even though they have a written agreement in this regard, because the Supreme Court has time and again said that maintenance is not something given by you, it's given by parliament, it's a legal right which can be only be taken away. It cannot be forfeited by anyone. If we want, we can say, okay fine, you are not entitled to maintenance. It's not you who can say, okay fine, I don't want maintenance. Okay, now what exactly are those 7 conditions? The first is adultery. Whoever have a outside sexual intercourse, here adultery does not mean that you have to have with a married woman also. Normally, the definition of adultery is if anyone have a sexual intercourse with a married woman. Here, if a person is having any kind of a sexual intercourse outside marriage, A and B are married and B a female or a male having a relationship with some other person. Here the relationship should mean sexual relationship. Relationship which is intimate and sexual. Intimacy is not the only question, that's why there's sexual relationship. And single act of adultery is enough for a divorce. You cannot say, okay, fine, just one time, so one night stand, forget about it. It's no reason for that. Even a single act of adultery or a, again, if a person is drunk. Now there's a question here. If a person has been involuntarily made drunk and then it happens, then what's the scenario? Here we can say that this is not also an act of adultery because it's forced one. So there the conditions differ actually. So again we have to see the cases in their own conditions and perspectives. Again, when you are dealing in a subject like family law, we are dealing with emotions, we are dealing with psychology, we are dealing with people actually. So you cannot have a straitjacket formulas. You have to sometimes bend the rule and sometimes change the rule. But the bend and change the rule should not be entirely against the basic norms. You can change and bend the rules, but it should be in accordance with your statute as such. Because as a law student, we know the importance of our statutes. And we have to work within the ball, we can think out of the box. Working within the four walls of statute, thinking out of the box. Okay? First is adultery. The second is cruelty. Now cruelty has been more defined. Cruelty can be mental, physical, emotional in a sense. That cruelty and it differs from one person to other. What can be cruel to you may not be cruel to me. So giving a definition of cruelty, I always put an important case in this regard is where a woman in fit of rage burned the thesis of his husband, PhD thesis of the husband. Now that amounts to cruelty. If somebody burns my thesis, I'll kill that person actually. Forget about divorce, I'll kill that person first. My entire 3 years of work, you burned it, and that point in 1970s, you don't have this desktop, I have a saved, I just need to print it out. The person who wrote the entire thesis, now he went there and binded up, and one day the woman, because she was angry, he burned the thesis. This is cruelty. We were laughing, but think about it. Your entire work, if somebody deletes everything in your computer, you have to submit next day all the projects. What is that? Cruelty to you? You will call it harassment? Right or wrong? So that means cruelty cannot have a single definition. Okay, fine, if somebody is slapping you in the public or beating you, for someone a single slap in public can amount to greater cruelty than someone who has been beaten up in the house. You have to understand that cruelty has to be understood in the way of social status. And it's not as if, okay, we cannot say, okay, fine, because the person belongs to lower strata, he's used to being beaten up. That is what I'm not saying, but I'm saying that you have to be different in your understanding, that how it differs from one person to another. There are students in the class who might keep on saying, okay, fine, don't do this, they won't matter, but if someone in class, if I say just once, and if you're not something wrong, he'll really feel it. And he might feel it so much, he'll be insulted with that account. So you have to think about all those scenarios. That's why Supreme Court never gave a definition of cruelty. This is the most important thing. Why didn't they never give? Because with the cruelty cases, you have to understand the circumstances. Now, everything they came with the general things. Look at these, if drunkenness, obviously the cruelty. Having regular. Now, this one word used by our Honorable Supreme Court and High Courts. There is a regular wear and tear. Now, I do not agree with this phrase because wear and tear happens in machines, not in relationships. That is a very insensitive remark made by Honorable High Court and Supreme Court. Wear and tear in a marriage. What do you mean by wear and tear? कहीं से marriage फट गई थी कि टूट गई थी क्या हुआ उसमें? No, so you have to take things in the spirit like that. Talking about the regular wear and tear. It also depends upon what kind of judge is sitting there, what kind of mentality he has. It depends upon a lot of things actually. What he thinks to be cruel. Again, it has a lot of bearing upon a patriarchal society also. What position do a woman know? He will, judge might say, okay, fine. He beat you, he slapped you 3 times. What a big deal. It's a normal wear and tear of marriage. One judge might take an offense. How could someone slap a woman? So, to extreme view. And that is what we call the subjectivity of the judge. So, it might be a problem for you in this regard also. If you face a judge who thinks that, if okay, we're slapping a woman 3-4 times or giving us few abusing, few motherfucker types of abuse is not a big deal actually. It happens in normal marriage. That can be one judge. No, they are our judges. And it is not, what I am saying is not hypothetical also. You can, if you try to search, it's a very common thing for judges. Okay, fine, normal abuses, if you abuse your family, what's a big deal? It happens in the marriage. And for some judge, it might be, how could you? How could you? So, You have to, with that you have to see the judge, what kind of judge you are faced with. That's one thing, but nevertheless you have never been given the definition of cruelty. The next is your desertion. What exactly do you mean by desertion? Somebody leaving? Not exactly. If I am forced to leave my house because of the conditions prevalent, then I won't be a deserter. I won't be, the person who has done the wrong will be a deserter. Example, see, normally we understood if someone leaves the house, normal understanding of desertion in our language is what the law says, if someone leaves out of a relationship and does not come back for 2 years. 2-year desertion. 2 years desertion can be actual also and it can be constructive also. Actual means I get up one day, leave the house, never come back. Constructive means we live in the same house but never as an husband and wife. As roommates. That's also a constructive desertion. Or I make the conditions so difficult for the other spouse that it's difficult for live for him. So he leaves it. Here also, I have not left it. So then also he can file for desertion because there is a constructive desertion. Again, there are certain conditions. There has to be 2 years continuous separating. Now it's not possible. A person, what can they do is, okay fine, 1.5 years they are gone. For next, in the 12th, on the 14th, 15th.